May I have my lord's kind leave to mention one matter? The compulsion, my lord. Actually, my lord, this is the order, my lord, passed by your lordship on 7/10/2024, directing the petitioner appellant to mention before the learned single judge and to fix the matter. But the same has not been fixed as yet, my lord.
What can I do on the
My lord,
administrative
if this
side?
can be assigned,
If it is released, I can assign it. As long as it is
but
not
it
released,
was from the November 2024, and my lord, this is 25, my lord, July.
you file some application in the matter and
I
then
have filed already, my lord. That application is still pending, my lord. I have nowhere to go. And it's a tender matter, my
once
lord.
again you try to mention.
I have already tried, my lord.
Tell that you came.
The Group
you came
9
to court.
matters, my lord.
No, you go to that court and say that you mentioned before court number 1, and we have requested you to mention it before the honorable judge once more.
Grateful.
May I permit to mention, my lord? My lord, there is a matter, my lord. I am mentioning for upgradation. The matter is regarding to selection process matter, my lord. Pending long time, my lord. I am for the respondent. I have respondent was participated in a recruitment process, my lord. His name was.
You do one thing. You mention on Monday.
My lord.
You mention on Monday.
May I be permitted to mention this matter, Your Lordship? There was an appeal which was dismissed on the ground that we will approach the appellate authority by filing an appeal within 60 days time limit. There is a miscommunication between the AOR and the client, and we couldn't file the appeal within the time period.
Of time.
Yes, Your
You
Lordship.
have filed an application?
No, we haven't.
No.
We'll
You file an application, give that number, we will list it.
all right, obliged.
Who will appear for the respondent?
Union of India.
You have to serve that advocate who appeared in that matter.
Okay, obliged.
Your Lordship, this is the leave to apply to file an appeal without certified copy. So, Your Lordship, I lost an reputation. I filed a
use the
an order was passed in a reputation on 8 February. The review. That review was dismissed on 7th July. Now, Your Lordship, there was a corollary proceeding in contempt with regard to that order, which I lost, which I suffered an order. That amount which was secured before the Registrar General an order has been passed yesterday to disburse that amount. So, the proceeding is the same, Your Lordship, just there are 3 orders. So, I need to file an appeal urgently without the certified.
No, it is in group 9, is it?
In group 6.
Group 6.
Your Lordship has the determination, Your Lordship. Just yesterday, the order of disbursement has been passed, and on
So against the order of disbursement,
now I have to file the order of disbursement, dismissal of review, and dismissal of my writ petition, Your Lordship.
Then it will be out of time.
No, Your Lordship, the dismissal has been done on 2nd July.
Okay, leave grant.
I'm so grateful.
With your Lordship's permission.
Yes.
My Lord, the matter relating to the violation of the Forest Rights Act in Great Nicobar, the matter was supposed to be listed for hearing on 15th of May, my Lords, where pleadings were complete and it was fixed for hearing on the 15th
that determination is no longer with us.
My Lords had spent considerable time on the matter and affidavits and opposition affidavit. All the pleadings are complete, my Lord. If my Lord may have.
Please mention it before the bench having determination.
Yes,
I think it is AD1's bench.
Yes.
You try, circulate a letter. Definitely matter will be listed.
Deeply obliged.
May I?
Because
yes.
May I please, Milord, kindly leave to mention one matter under extreme urgency, Milord. Milord has already pronounced a judgment in the month of May, Milord. My other side has been on notice, and on his request I'm mentioning today, Milord. The matter is, Milord has passed certain substantial question of law in our favor, in the favor of revenue, and other questions in favor of the respondent. And in the last para, page 7, it is said that which has been decided in our favor is decided in their favor. So in accepting, actually, I've been told that we are in the process of accepting this judgment. So there is some procedural difficulty with that.
No, the last paragraph, in the last paragraph you have said, the appeal is partly allowed and the substantial questions of law 1 and 2 are answered in favor of the revenue. What should be the question?
The question number 3, actually there are a payment 26 crore they have paid voluntarily, which the learned tribunal remanded to the adjudicating authority to decide afresh.
So
But
one,
Millard
one,
has decided
1 and 2 should be answered against the revenue, 3 in favor of the revenue, correct?
in Millard actually the partly because with respect to the only the payment that they have voluntarily done, Millard.
No, let's
May
see
be
the
listed on any day next.
But what to do? They have to file an application. It is better that if you file an application, because the order has already been signed and uploaded.
Mm.
Yes,
Yes, sir.
you file an application tomorrow, we will list it next week.
But I have to again vet it, so I'll file it tomorrow, next week, because there are certain procedures to be
File the
followed.
application and give the number, we'll list the application. And you serve a copy of the application.
Well, may I permit to mention with regard to the item number
Please,
94 from the month list, I am praying for the upgradation in this matter. What is a matter of Monday?
I have your lordship's leave to
Your
mention
Lordship,
one
I am
mention.
petitioner in person in WPO 518 of 2024, and this was in court number 3. I have approached you on this matter earlier also. You had told me have some patience and wait for thing. Today I went to Justice Gauranga Kant. Third time I mentioned, and I told him the urgency of the matter is that in nexus with the police, there are 4 judicial orders in which his order is also there with Justice Bakshi also. No criminal activities. 4 judicial orders have been disobeyed. Police in nexus with the respondents has completed the construction. The KMC in their report in the written statement has confirmed to the police that they have already issued the notice on the building. And here KMC is also confirmed in the written statement that there is illegal construction done. Taking into account that 1 year has passed, and earlier it was with Justice Kaushik Chandra, then I came to you, then again it went to Gauranga Kant, then again I came to you. Then you said, wait for some time. Now, third time I did my mentioning, and I said the very case is being defeated, because if somebody is already constructed with nexus with the police, and then I'm coming to you, then I feel that, I requested that your lordship kindly release my matter. He said that you go to the Chief Justice. I said, I have gone earlier to the Chief Justice on the same matter. He told me to wait patiently. I waited 3-4 months. I mentioned 3 times, and today also I've mentioned, then I've come to you, your lordship. I just want your intervention, your lordship, because
See, the problem is, on the administrative side, a Chief Justice can assign a matter if it is released. I cannot pull out a matter from a particular court. If suppose there are 2 or 3 connected matters and it is scattered in 3 courts, then one court will make an observation saying all 3 has to be heard analogously. Then I can exercise jurisdiction, call for the file, examine the file. If it is connected, we can do. In your case, how do we tell the judge you take up the matter at the first item? We can't.
Yes,
I can't do that.
I'll just mention it. When Justice Gauranga Kant tells me just now that go to the Chief Justice and make a request, and then I'll release your case. You see, I made a request. I know
all right, you give the letter.
I made a basic law that you release my case. He said, no, go to Chief.
All right, let us see what can be done about it.
May I have lordship's leave? Upon notice, I'm mentioning for inclusion for admission group 6, madam.
May I have your lordship's leave to mention one matter for admission of appeal under section 30 of the Employees Compensation Act, my lord.
My lord, may I permit you to mention a group 6 matter modification application, your lordship, for inclusion, my lord.
Modification of who? Which order?
Modification of order of the Honorable Justice Subroto Talukdar and Lopita Banerjee, your lordship.
Then you do one thing. You give this letter to the OSD.
Lordship.
Because you explain to him, Anjali.
Grateful.
Yes, please call.
Original site daily list item number 1, new applications.
This is a revenue appeal. It's below the monetary limit, my lord.
My lord, we have received the opposition, my lord. We will file reply. Kindly fix the matter after 2 weeks, my lord.
The tribunal's order starts at page 13. The amount is mentioned at page 14, third line.
But even in the grounds, they will mention one paragraph.
But they have not.
Page number 14.
14. Third line. That the
My
tribunal.
lord, they have filed the opposition, my lord, 2-3 days ago, my lord. If your
But we
lordship,
have
my
got
lord,
the opposition to the delay. There's also a delay, but this is below the monetary limit. 1 crore 12 lakhs.
What do you say for this, Mr. Bhattacharjee? Page
my lord,
14.
page 14 of the stay petition, my lord.
1-4.
1-4, my lord, may I, my lord.
Third line from the top.
So that is easy. That is there, my lord. That is there. It is really, my lord, 1 crore 12 lakhs is there, my lord. That is below monetary limit.
So what we can do is, we will
my lord,
condone
only
the delay.
question is a question of law, my lord, pertaining to this matter, my lord. The notification
we
says
leave
if
it
there is
open,
a
sir.
substantial question of law involved, then your lordship can hear out the appeal, my lord.
No. What is involved here? Where are your questions?
That is also a
My lord,
classification issue.
End user, my lord, end user is at India. My lord, the respondent is in Germany. He received order for supplying goods at India, my lord, end user at India. That's why we are saying, my lord, that he is liable to pay this, my lord. He is saying it is
Also
an
a
export service.
classification
We are
issue,
saying it is
which is
not
at
an export
para
service.
six.
No. If you see paragraph 7 of your stay petition, page 5, the first question is factual. Second is also appropriate rate relatable to question number 1. 6 is, C is also there. And this is not a recurring issue which will have an effect. And apart from that, they say that.
But page 15, para 6 of the tribunal's order, clearly noted it's a classification issue. Para 6, page 15.
Whether it is a export service or not, that is the only issue to be decided by lordship.
No. Please come. This is an appeal filed by the revenue.
My lord, kindly condone that. My lord, kindly condone the delay, my lord.
Definitely. Under section 83 of the Finance Act, 1994, challenging the order dated 10/10/2023, passed by the Customs, Excise and Service Tax Appellate Tribunal, Eastern Zonal Bench, Kolkata, within bracket Tribunal, in Service Tax Appeal number 127 of 2012. The revenue has raised the following substantial questions of law for consideration. Page 5 and 6, A, B, C, and D. We have heard so and so. There is a delay of 327 days in filing the appeal. Though the explanation offered is not fully satisfactory, considering the facts of the case, as also the objection raised by the learned advocate appearing for the respondent as to see that this appeal is below the monetary limit fixed by the central board, we exercise discretion and condone the delay in filing the appeal. As could be seen from the impugned order passed by the learned tribunal, the demand of service tax including cess is rupees 1, 12, 87, 367. If that be the case, the matter is well below the monetary limit fixed by in the circular issued by the board, and the revenue cannot pursue this appeal before this court. Accordingly, the appeal stands disposed of on the ground of low tax effect, and consequently, the substantial questions of law are left open.
Grateful, my lord.
I'm grateful, my lord.
Yes.
Grateful, my lord.
Item number 3.
Item number 2.
Yes. This matter, my lord, there has been direction for service to the department. Since the service was returned with postal remark not
what happened? And we also gave liberty to serve Mr. N.K. Chaudhary.
That is there, my lord. There has been some mistake on my part, my lord. It could not be done, my lord. Your lordship kindly take up the matter.
List the matter after 2 weeks. By then, service of notice, as directed in the order dated 26 June 2025, shall be complied with.
For admission of tax matters, item number 3.
In terms of your lordship's order, my lord, report is ready, but is lying with land ASG. My lord, he is coming. If your lordship kindly, my lord, give some, my lord, time of short passover, my lord.
What is this matter?
Regarding
that
that, my lord, bill payment.
Well, they have given report on last occasion by the ASI, and there is a
Then what you
discrepancy
can do
shown.
is, don't trouble ASG today. Get a copy of the report and give it to Mr. Roy Choudhury. Let him go through it. We'll have this matter on Monday.
Very well, madam.
In the meantime, my affidavit is personal affidavit.
The affidavit filed by the learned senior standing counsel is taken on record. It is submitted by the learned advocate for the respondent, learned government counsel, that the report which was directed to be filed is ready, and the same will be filed during the course of the day. Let a copy of such report be furnished to the learned senior standing counsel for the department. List the matter on Tuesday. Monday there is some problem.
Item number 4.
Your Lordship, I'm praying for a short Passover in this matter. Your Lordship, my learned senior is on legs. He's arguing another matter.
See, we have got only 10 matters on the original side. Then we will switch over to appellate side.
I've informed
My
Your
lord,
Lordship.
there is a my lord, subject to absolute correction. My lord, there is a direction upon the my lord, appellant to file one report, because my lord, there was a my lord, observation by your lordship that my lord, in the my lord, tribunal they have taken 18 times of adjournment, and there is one some aspersion among the learned advocates. That's why my lord, last occasion your lordship kindly see.
Lordship, the affidavit is ready. It could not be affirmed because the client has been slightly unavailable due to some medical
All right,
issue.
we'll have it next Wednesday.
Lordship.
Before that, you get it affirmed, serve a copy on
Lordship, I
Mr.
shall do that,
Bhattacharya.
Your Lordship.
The learned advocate appealing for the appellant submitted that the affidavit which was the report or affidavit. Learned counsel for the appellant submits that the affidavit which has been which was directed to be filed by order dated 16th June 2025 is ready, but yet to be affirmed, and the same will be affirmed and filed before this court within this week. Full stop. Let a copy of this report, the affidavit, be served on the learned senior standing counsel appearing for the respondent. List on next Wednesday.
Lordship. I'm grateful, Your Lordship.
Item number 5.
I'm afraid.
May it please your lordship. This is my lord, a reopening procedure, my lord, on the basis of which my lord, this was done, was my lord, the unexplained cascading under section 68. Now, my lord, the relevant finding, my lord, of the assessment.
Are you not
Tax
getting?
effect is 13,90,000. And tribunal considered on merit, if your lordship see, page
No.
30.
Are you not sick of the 68 matters?
68 my lord has given us a real trouble, my lord. We'll only finding out whether three things, my lord. I must be very candid before lordship, my lord. The identity, creditworthiness, genuineness, my lord. These are to be, my lord, separately
But,
dealt
what
with.
do you say about this tax effect?
Tax effect, my lord, the contention of the revenue is that it falls under the exceptions clause of that CBDT circular. So, my lord, even my lord, the tribunal, my lord, did not travel that aspect too much. But, my lord, the assessing officer,
Yes,
my lord,
my
has recorded certain facts, my lord. If your lordship kindly turn to page
13,90,300.
Yes. Lordship, you see tribunal order, relevant page 31, my lord, of para 4. Lordship will get entire history of this matter, my lord. After hearing the rival contention and perusing the material available on the record, I observed that the case of the assessee was reopened for the reason that the assessee has received 45 lakhs as share application money, which is nothing but an accommodation entry under from Messrs. Ajanta Banijya Private Limited. The London assessing officer recorded the reason for reopening of the assessment, copy of which is placed on record at page
10, 11. Then Lordship kindly come to the relevant middle. The learned AR pointed out that the facts recorded by the learning assessing officer are incomplete, as the learned assessing officer has taken only the share capital of 44 lakhs 50,000 and not net profit of 40 rupees 41,358, while capital reserve was 3 crore 91 lakhs 45,000, which was coming from the earlier year, was not considered. The total funds such as share capital, reserve and surplus, and net profit are to be taken into account for determining the creditworthiness, where the learning assessing officer had omitted to consider the amount capital reserve, which recording the satisfaction as the creditworthiness of the investor. My lord, then middle portion, I am of the view that the reason recorded by the assessing officer are incomplete, and therefore the assessment framed by the learning assessing officer cannot be sustained. The case of the assessee finds support from the decision of the Honorable Bombay High Court in case of Hindustani Liver Limited. That was considered, that judgment I have, my lord. Then the
No, my lord, the assessing officer, my lord, while recording, my lord, the facts of this case, my lord, have elaborately gone with this issue. If your lordship kindly turn to page 9 of the assessment officer order, because my lord, then my lord, it has my lord went up to the CIT appeal, and my lord, CIT appeal, my lord, have endorsed my lord the finding of the assessing officer. So my lord, today, my lord, my learned friend, my lord, is actually, my lord, trying to, my lord, establish, my lord, the against the concurrent finding of both the authorities. If your lordship, my lord, kindly turn to page 9, the genuineness, my lord, and there was, my lord, the summons that has been issued to the, my lord, the directors of the company, and their question answer, my lord, has been reproduced and has been made a part of the assessment officer.
No. Who is the share applicant? Subbalakshmi Chemical.
Subbalakshmi Chemical.
Yes. Subbalakshmi Chemical.
That they are the assessee, and my lord, the company that had invested, my lord, in the form of share, the director of that company, my lord, has been called upon, and my lord, has been examined, and the respective answers given by the director, my lord, is reproduced in the tabular form.
But it was recorded after the reason to believe.
Yes.
During the course of reassessment.
No, pardon, come again.
It was recorded, the director statement was recorded after the reason to believe during the course of reassessment.
Yes.
At the point of reassessment, there was no such reason to believe.
No, my lord,
they have
this factual statement was not part of the reasons for
no, my lord. If you see page number 9, para number 2, the notice under section within the lines, notice under section 131 of the Act was issued to the director, managing director of the above mentioned companies on 12/11/2018 for his personal appearance on 19/11/2018 with certain details document information. In response to the said notice, Sri Parmeshwar Tapadia, one of the director of Ajanta Vanija,
148 notice was issued on 23rd of March 2018.
My lord. Then thereafter, my lord,
then it can be, at best give you a fresh cause of action for a second notice, but not, you can't substantiate that notice with some reasons which are recorded post that notice.
Yes,
ma'am. If I could, my lord, only indicate that, my lord, 148 notice by virtue of which, my lord, the assessee was, my lord, asked to, my lord, file a return, that was, my lord, done on the basis of the materials, my lord, that was lying in the hand of the assessing officer.
Therefore, you issued the notice on 23rd of March 2018. He submitted his objections on
4th September 2018.
Where do you get the date?
My lord, it is written in page number 8, second para, last 3 lines. SSC filed an objection letter against the proceeding initiated, which was disposed of by speaking order and conveyed to the SSC by.
After that,
yes,
when you took up the reassessment proceedings, you issued notice to the, under 131 to the director, recorded his statement, and based on that you reassess the entire income, not based on his original return filed in pursuance to the notice under 148.
May I only indicate that, my lord,
this has not been, you didn't argue this point before.
No, that was not taken, my lord.
My lord, I was not.
That has not been taken
Because
in either of the.
in the question of law, they are also relying on the statement of Mr. Taparia, but it was recorded post reassessment.
Now,
what do you say about this reserve of 3 crore 91 lakhs?
That is something which is with regard to the credit worthiness of the investing company.
And as per this statement post the rejection of his objection, he says that they are all our relatives.
Yes. So
we have allotted share to them.
The contention of the assessing officer, this is a ploy, to brought back that unaccounted cash in the books of the assessee. So that is this.
On this point, you have to fail. You will fail. You could not have relied upon a statement which was recorded after his objections were disposed of by a speaking order.
Yes. May I only say 148 notice is actually empowering assessing officer to call for return from the assessee in respect of a previous year.
But that
Now,
was
the reason for which that exercise has been undertaken, the materials has to be there in the hand of the assessing officer. Now, during the course of the assessment procedure, once the assessee filed the return, here the assessee has filed return, then the entire process, it has to be treated a de novo assessment proceeding, and the entire materials that can be brought to verify the genuineness of the transaction in question can be looked into. It may not be required at the time of opening of the assessment procedure.
In his reply to the 148 notice or 142.1, he has said that is extracted by CIT appeals in page 14. You come to that extracted in
page number 14.
The last 5 or 7 lines. The authorized representative of the assessee, who had reply dated so submitted that while questioning the financial capacity and creditworthiness of the creditor, the fact that the creditor is having a reserve to the tune of 391.50 lakhs in addition to the share capital of rupees 44.50 lakhs, thus having a total shareholder fund of 436 lakhs, has been escaped to be considered. As such, the very basis of reopening under 147 is not tenable.
Based on this finding, ITAT has given is the relief.
Then you come to page 15. This the extracted in italics about 10 lines from the bottom of that paragraph. The AO overlooked the fact that the identity of the investor has been proved. You did not dispute it. They have sufficient net worth to invest, and the transaction being routed through banking channel and disclosed in the books of both the parties. As such, the genuineness of the transaction is proved. While passing the assessment order, AO wrongly made addition invoking section 68 without discharging the burden to show that though covered by checks, the amounts in question actually belonged to or was owned by the appellant himself. Overlooked the fact during the course of appeal for the assessment year 1213, CIT appeals accepted the genuineness and identity of the investor. Hence, this appeal owns.
And in page number 12, Your Lordship, we have submitted PAN, ITR, financial statement, everything.
some reasons were given to reopen the assessment, show cause notice given. He submitted his objection. That objection was not rejected.
Yes.
But some order was passed in the sense that the objection or the factual submission was not found to be incorrect. Correct?
Yes.
But nonetheless, you rejected the objection. Then while completing the reassessment, you took some other material and did that. That is wrong.
And my lord, we have a decision of Bombay High Court.
Yes.
If the reopening is based on incorrect facts, then it is without application of mind and they have already quashed it.
Yes.
Para number 9, page number 3. We agree with Mr. Kapadia that the reasons recorded are based on incorrect facts. We also agree with Mr. Kapadia that no attempt has been made to deal with that with this error in the order on objection, and the order on objection in fact has more errors. All this indicate total non-application of mind, and certainly adverse inference has to be drawn against the revenue. Para number 10, as held in Ankita Choksi, the condition precedent of a reason to believe that the income chargeable to tax has escaped assessment on correct fact must be established by the AO, so has to have the jurisdiction to issue the reopening. In the present case, the AO proceeded on fundamentally wrong facts to come to a belief or conclusion that the income chargeable to tax has escaped assessment. Further, even when the same is pointed out by the petitioner, the AO is in his order disposing the objection does not deal with the factual position. On the facts, therefore, there can be no reason for the AO to believe that the income chargeable to tax has escaped assessment.
And you see CIT appeals order.
Yes.
I thought up to page 16, up to page 16,
Only para
only
4.1.
one paragraph. Please come. This appeal by the revenue filed under section 260 cap A of the Income Tax Act 1961 within bracket the Act is directed against the order dated 15/2/2024 passed by the Income Tax Appellate Tribunal SMC Bench Kolkata within bracket Tribunal in ITA number 992/KOL/2023 for the assessment year 2011-12. The revenue has raised the following substantial questions of law for consideration. Page number 4 and 4, page number 4, A and B. See notified. We have heard so and so. The revenue is aggrieved by the impugned order passed by the learned tribunal, by which the assessee's appeal was allowed, and the order passed under section and the reassessment order passed under section 143 within bracket 3 read with section 147 of the Act dated 26/11/2018 as affirmed by the appellate authority by order dated 24/7/2023 were set aside. The tribunal has made a thorough examination of the factual position, and it found that the facts recorded by the assessing officer are incomplete, as the assessing officer has taken only the share capital of rupees 44,50,000 and net profit of rupees 41,358, while the capital reserve of rupees 3,91,50,000 which was coming from the earlier years was not considered. Therefore, the tribunal observed that the total funds such as share capital, reserve and surplus and net profit are to be taken into account for determining the creditworthiness, whereas the assessing officer has omitted to consider the same the amount of capital reserve while recording his satisfaction as to the creditworthiness of the investor. One more issue which is apparent on the face of the reassessment order is that the notice under section 148 of the Act was issued to the assessee on 23/3/2018 and the assessee filed his return of income on 31/7/2018. Thereafter, notice was under section 143 within bracket 2 was issued and served on the assessee on 6/8/2018, and subsequently a notice under section 142 within bracket 1 of the Act along with the questionnaire was issued and served on the assessee on 28/2018. The assessee filed their objection to the reasons which were recorded in the notice dated 23/3/2018. However, the assessing officer disposed of the objection, rejecting the stand taken by the assessee by an order dated 11/9/2018. Thereafter, reassessment proceedings were initiated. And during the course of reassessment proceedings, notice under section 131 of the Act was issued to the director/managing director of the company on 12/11/2018 for his personal appearance, and a statement was recorded. Based on such statement, the reassessment order was passed. Thus, it is evidently clear that the statement which was recorded on 12/11/2018 was much after the notice which was issued under section 148 of the Act dated 23/3/2018, and therefore, even assuming there was some material in the statement, the same cannot justify reopening of the assessment. Therefore, the reopening of the assessment is bad in law. Apart from that, as observed earlier, the learned tribunal has noted the facts and has also taken note of the submissions made by the assessee as regards the documents which are placed by the assessee before the assessing officer during the reassessment proceedings, and there is no observation made by the assessing officer rejecting those documents or stating that the stand taken by the assessee is incorrect. In such circumstances, the learned tribunal was fully justified in allowing the assessee's appeal. Thus, we find no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, appeal is dismissed.
Obliged. Grateful, Mahila.
Item number 6.
Respondent served.
My lord, respondent is not appearing. It was served, but is not appearing. In another case of this assessee did not turn up.
Did they appear before the tribunal?
No. Yes, my lord. And this for another assessment here, my lord, the my lord has passed an order in favor of the revenue, my lord.
Oh, against the common order,
Yes, common order. My lord, kindly see this order, my lord, the brief.
So it is covered by decision.
No, my lord, the finding is different. For this, in this case, the finding of tribunal is different.
No, but it is a common order in both the appeals.
My lord, kindly see the order once, my lord. Page 74.
74, yes. You see the top ITA 257 and ITA 258.
But in 258, the tribunal has given different, has
Where-
taken a
where-
approach is different, my lord.
Oh, page number 76.
76, my lord. The paragraph 4, 258.
And what is your
First of all,
submission?
my lord, here the tribunal is saying the unaccounted purchase. The assessing officer, while making the addition, has failed to bring on record any evidence from which it can be established that the assessee has made any unaccounted purchases, but it is a bogus purchase. And my lord, it was established that the purchases made by the assessee was bogus. In the that connected assessment year, my lord, the previous assessment year, the tribunal also held that the purchases were bogus.
Which assessment year?
In the 11-12, the common order. And my lord, kindly see one. Kindly come to page 34, my lord.
30?
The 34 assessment order, my lord. But no reply has received against the show cause notice. Notice of summons under section 130 of 131 of the Act was issued the assessee, and as per the statement recorded, Sri Abbas Yusuf Ali Hanif, partner of Messrs Advanced Engineering Corporation, the assessee, himself admitted that his firm was unknowingly indulged in fraudulent activities, and henceforth for the firm will be careful in future. In this case, my lord, the investigation wing had made a detailed investigation into the matter, and as per statement of Sanjeev Kumar Singh, he had admitted that he used to give.
In fact, that we have noted.
Yes, yes, my lord, that has been noted.
In that case, the learned tribunal
had made addition of a certain percentage, 8%.
8% as a gross profit. Here they have deleted the
entire deleted.
So factually it is covered.
Yes, factually it
but
is
though the reasoning is slightly different.
Yes.
Please come. This appeal filed by the revenue under section 260 cap A of the Income Tax Act 1961 within bracket the Act is directed against order dated 12th December 2023 passed by the Income Tax Appellate Tribunal SMC Bench Kolkata within bracket Tribunal in ITA number 258/KOL/2023 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Page number 5 and 6, 1 and 2. The learned tribunal passed a common order for 2 assessment years, namely 2011-12 and 2012-13. The present appeal relates to the order passed by the learned tribunal for the assessment year 2012-13. As against the order for the assessment year 2011-12, the revenue filed an appeal before this court in ITA 266 of 2024, which was allowed by judgment dated 9th June 2025. The factual position in both the cases are identical, though in the case relating to the assessment year 2011-12, the tribunal, though held against assessee substantially, ultimately while passing the order took a lenient view and observed that in the interest of justice, the assessee's gross profit in respect of the alleged bogus purchases can be fixed at 8%. This finding was not approved by this court and the appeal filed by the revenue was allowed. The operative portion of the judgment reads as follows. Page 2 till the end. The factual position which have been brought out in the above judgment with regard to the role played by an entry operator, one Sanjeev Kumar Singh, has also an impact for the assessment year 2012-13. However, the learned tribunal ignored this aspect of the matter and deleted the addition made by the assessing officer. As held in the aforementioned judgment, the facts were clearly established that the assessee is one of the beneficiary of the bogus sales of goods through dummy entries to various beneficiaries in lieu of commission. And this aspect has been very elaborately brought out in the assessment order dated 27/12/2018, passed under section 143 within bracket 3, read with section 147 of the Act. Further, the statement which was recorded from various witnesses, including that of Sanjeev Kumar Singh, were considered. And after considering the entire modus operandi, the assessing officer arrived at a conclusion that the expenditure is bogus and consequently the commission said to have been paid from an undisclosed source was also treated as unexplained expenditure. This order passed by the assessing officer was affirmed by the affirmed by the Commissioner of Income Tax.
36, my lord. CIT appeals order, my lord, at page 36.
Was affirmed by the National Faceless Appeal Center within bracket NFAC by order dated 27/1/2023. The tribunal, while allowing the assessee's appeal, has not discussed any of the facts and in a single line stated that the assessing officer, while making the addition, has failed to bring on record any evidence from which it can be established that the assessee has made any unaccounted purchases from any party. This finding recorded by the learned tribunal is factually incorrect, as could be seen from the assessment order, reassessment order, as well as the order passed by the appellate authority. Thus, we hold that the order passed by the learned tribunal calls for interference. Accordingly, the appeal filed by the revenue is allowed and the substantial questions of law are answered in favor of the revenue. Sir, first line you add that though notice has been served on the respondent assessee, none appears for the respondent.
Ungrateful.
Item number 7.
So it was served, it was returned on the ground that no such person found in the address.
Fresh notice.
Email service.
Or in addition, let fresh notice be issued, served on the respondent assessee through the department, and in addition, by email to the registered email ID of the respondent assessee.
Grateful.
Item number 8.
For the respondent.
My lord had directed me to take instructions regarding tax effect. My lord, I have taken instructions, but the view of the department is different. Here, my lord, the fact is that, my lord, there's a penny stock case, but the assessee had disclosed that income derived from the sale of shares as income from other sources. And that income was adjusted with
So according to you, it is a case of organized tax evasion.
And my objection was that since it has been disclosed, so then penny stock is not the mallet. In fact, even the tribunal has gone on that basis, mallet, because the circular through which they've carved out an exception. Mallet, may kindly have a look at it once. My lord, may see the last line, my lord. It says, shall not apply in case of assessee claiming bogus LTCG or STCL. My lord, the word is claiming. So, my lord, I have not claimed anything. I have offered it for tax. My lord, the penny stock, the income from that has been offered to tax.
And show the finding of the tribunal.
My lord, may take page 77, my lord.
There are no page
tribunal's
numbers.
order is at page 75.
No, you give the internal page number because stay petition doesn't contain page number.
My lord, internal page will be page number 4.
4.
Para 3.3, my lord.
Without going into the controversy as to whether the shares of so and so were penny stock or whether the assessee was a bona fide purchaser said shares, the assessee himself has offered the income from sale of the said shares under the income from other sources. Whether the income can be taxed twice.
My lord, there's one more thing, my lord, if I may put it in this manner. My lord, at that particular time for 15-16, my lord, even the tax slab was taxing me under 68 was 30%, not 60%. My lord, now it has gone to 60%, so it was 30% under 68 also, section 115 BBE. So, my lord, the assessee had paid tax, so that is also 30%, and 68 also was 30%. Now it has gone to 60%. So, at that particular, my lord, may see that this is what even the tribunal has done that. And the slab of tax under section 68 is the same at which the assessee has offered the set income.
Where are you reading?
My lord, para 3.3 only, my lord. After tax twice, my lord. Since the assessee has offered the said gains income as income from other sources, and the slab of tax under section 68 is the same at which assessee has offered the said income after set off of losses.
And what are your grounds you have raised?
Page 7, my lord. SQL is page 7.
But then if he has already paid tax by showing it as under the head
Offered for tax, my lord, not paid because that profit was adjusted with a loss.
Maybe, but then he has offered it for tax under the head. Now, if you do it under 68, will it not be a double addition? But in your first ground, you say that is perverse. How do you say it's perverse? Then the other grounds are not there. Only one ground.
My lord, then other ground is there that, my lord, I had a bad debt also, a loss which was my incident.
No, have they raised that?
That is
commission also they have
ground
raised.
five.
Not raised that, my lord.
No, commission they have raised.
No, ground 5, my lord.
My lord, that is there, my lord, ground 5.
Oh, that was on the assumption that the assessee has dealt with penny stock.
No, my lord, that is, my lord, on the same thing, my lord, there was a loss which had happened to me. My lord, a loss which was incidental to business. So, my lord, against that, I had set off this.
That was a spot exchange, national spot exchange. Actually, what had happened during that period, my lord, there was a scam. National spot exchange. Several investors were cheated out of their money. In the garb of offering guaranteed returns of 12% that time, my lord. And that subsequently it was found that the several investors' money were siphoned off. and they were not paid after intervention of the courts and with the SEBI. Some of the investors got their money back.
So he did not get that derivative.
Yes,
So
sir.
therefore he showed it as bad debt.
Yes, sir, from that.
So three issues, no? Question number 1, 4, and 5. Please come. This appeal filed by the Revenue under Section 260 Capital A of the Income Tax Act 1961 within bracket PI is directed against the order dated 20th May 2024 passed by the Income Tax Appellate Tribunal C Bench Kolkata within bracket tribunal in ITA number 672/KOL/2023 for the assessment year 2015-16. The Revenue has raised the following substantial questions of law for consideration. Page 7, question number 1, 2, 3 not required. Question number 4, question number 5, 6 not required. We have elaborately heard Mr. Amit Sharma, and Senior Standing Counsel for the department, and Mr. Kejriwal, and an advocate appearing for the respondent assessee. The assessee filed the appeal before the tribunal, challenging the order passed by the appellate authority dated 11/5/2023, affirming the assessment order dated 29 December 2017, passed under Section 143 within bracket 3 of the Act. The learned tribunal considered the factual position at the first instance and has pointed out that without going into the controversy as to whether the shares of Messrs. GCM, all capitals, Securities Limited were penny stock, or whether the assessee was a bona fide purchaser of the said shares, noted that the assessee himself has offered the income from the sale of the said shares under the head within inverted comma income from other sources inverted comma close. Therefore, the question which fell for consideration before the learned tribunal was whether the same income can be taxed twice. Furthermore, it is relevant to note that the assessee has offered the said gains/income as income from other sources inverted comma, and the slab of tax under Section 68 is the same at which the assessee has offered the said income after set off OFF, then OF losses, and even for the year under consideration, there was no bar to set off losses against the income assessed under Section 68 of the Act. Therefore, the tribunal concluded, in our view rightly, that the assessing officer was not justified in making the double addition of the same amount. The next issue before the learned tribunal was with regard to the addition of rupees 2,47,898 made by the assessing officer on the assumption that the assessee might have paid some commission to earn bogus LTCG, all capitals. The tribunal set aside the said addition on the ground that it was purely on assumption. And therefore held the addition to be not sustainable and accordingly deleted the same. We find no grounds to interfere with the said finding passed by the learned tribunal, which has tested the factual position and arrived at a conclusion. The third issue which fell for consideration was with regard to disallowance of the loss on account of bad debts. The learned tribunal has elaborately considered the submissions made by the assessee and found that has recorded a finding that the revenue could not rebut any of the contentions raised by the assessee. That apart, the assessee has offered the aforesaid loss during the course of his business in derivative segment, since the amount was paid by the assessee and commodity was not delivered to the assessee due to scam in the National Stock Exchange, and the amount was treated as bad debt and written off. Therefore, it was concluded that the assessee was justified in claiming the same as loss on account of bad debt written off. Furthermore, during the year under consideration, there was no bar to set off losses against income, even assessed under Section 68 of the Act. With this reasoning, the learned tribunal deleted the addition. Thus, we find the entire matter to be factual and no question of law, much less substantial question of law, arises for consideration. Then we return to our next.
Item number 9.
Your Lordship, in this matter, Mr. Parsi is appearing in person. My Lord, kindly keeps it on 25th of this month. He's appearing for the respondents.
He yesterday telephoned me. No objection.
Deeply obliged.
Item number 10.
I understand that your losses desired that reports should be filed. In respect
no,
to item
the
number 3,
council.
my girlfriend is appearing.
No, council said that report is ready.
Yes, yes.
And you please give him a copy.
Yes,
You let him go.
Yes, my lord. And my lord, the only thing is I am submitting, in spite of your losses, a specific earlier order and the last order. No application has been filed by Mr. Raishadip's department. No affidavit, nothing.
I today filed.
Only every day, my lord, oral submissions are being
Today
made.
I filed.
Today he has
copy
filed.
was given.
To whom it has been given?
No.
To.
Well, I am submitting the.
No, we have adjourned the matter to next week. You'll please furnish a copy. You please give one extra copy.
Yes, I'm giving.
Where is that? Right away, you hand it over.
May I hand over your losses copy? Yes. And it is his copy. All the questions raised by your lordships have been answered too.
All right. We'll go through it.
Yes.
Along with all of you.
And
Then you have to change the order.
principal commissioner.
The report filed by
The principal commissioner of income tax came to my chamber. He is taken aback to see that the TDS certificates my learned friend is practicing on the income tax side. He is aware that these are under section 26A available in the server for the last few years.
We can download it.
Yes, I am downloading it, filing my return.
Issue is not that. After that Miller's order, they have given it to me. They can say you
No,
can
you
download
need not
it.
ask them. You can go to the
Anyhow,
website
now
and
the
download.
issue is the last occasion, my lord, the ASG, Learned ASG, give a copy to my lord. In page 44, there's a list of fund discrepancies where 2 judges are now sitting judge. Their amount is more than 25 lakhs. And I personally informed them, they reacted.
All right. We will take it up next.
No, after 10 days, kindly give it up 10 days.
All right.
Because
After 2 weeks. Next.
Item number 10.
Respondent served.
Respondent.
Who appeared? Somebody appeared. Then you inform Prithvish Junjunwala. Miraj D. Shah appeared.
Actually, will not find beyond. There is a limited scope.
Limited scope.
Scope. Because
What is the issue?
because we are the
Oh, it was the department's appeal before the tribunal.
department appeal before the tribunal without CIT.
You switch on the mic.
The CIT appeal without categorical finding. Thereafter, without ITAT also categorical finding. Without I find from the ITAT order that it says without the periodiness, genuineness, and without and without everything. You also kindly see page 32, 33 of the CIT appeals order. Thereafter, your lordship kindly see, my lord, the from the my lord,
Yes. They filed a detailed paper book.
Yes,
CIT
yes.
appeals has examined it.
Thereafter, your lordship, kindly see page 40,
Hmm.
the tribunal's order. The
42.
tribunal categorically held that the identity, thereafter the creditworthiness, and thereafter the genuineness has been proven. Little scope, I do not fight for the only for the fighting.
This appeal filed by the, please take note. Appeal filed by the Revenue under Section 260 Cap Clea of the Income Tax Act 1961, within bracket the Act, is directed against the order dated 1/1/2024 passed by the Income Tax Appellate Tribunal, B Bench, Kolkata, within bracket Tribunal, in ITA number 40/KOL/2021 for the assessment year 2012-13. The Revenue has raised the following substantial questions of law for consideration. Page number 5, A, B. That is sufficient, sir. C, D, not required. We have elaborately heard Mr. Soman Bhattacharya, learned Senior Standing Counsel, for appealing for the appellant Revenue. The appeal filed by the department before the learned tribunal, challenging the order passed by the Commission of Income Tax, within bracket Appeal 7, Kolkata, within bracket CITA, dated 22/9/2020, was dismissed. The CITA, by the said order, had set aside the assessment order passed under Section 143, within bracket 3, dated 12/3/2015. The question, the matter relates to whether, the issue is whether the assessing officer was justified in invoking Section 68 of the Act. The learned tribunal noted the three factors which are required to be satisfied. Namely, the assessee should establish the identity and creditworthiness of the shareholders and also prove the genuineness of the transaction. The three aspects have been elaborately dealt with by the learned tribunal while affirming the order passed by the CIT. In fact, the learned tribunal in paragraph 7.2 has quoted the factual finding recorded by the CIT. Apart from that, the learned tribunal has also perused the paper book and documents which were placed, from which it was shown that all the share applicants are income tax assessees, they are filing their returns, share application forms and allotment letters is available on record, share application money was made by account payee checks, details of the bank accounts belonging to the share applicants and their bank statements were produced, none of the transactions are any deposit of cash before issuing checks to the assessee, and all the share applicants have substantial creditworthiness represented by their capital and reserve. Thus, the matter being entirely factual, we find no question of law, much less substantial question of law as this occurs. According to appeal fees.
Adipto.
Appellate side, daily list, serial number 1.
टाइम चाहिए बच्चे तो हाँ टाइम में वो तो ये लगा आपकी बीट का पेज ही आपकी बीट का पेज ही तो टाइम में वो ठीक है तो
Cost list is the cost list. Only original side, no problem. One copy you give. Yes, sir.
So what happened, Your Lordship, in this purported year, I'm reseller of taxable goods, Your Lordship. I made intrastate sale as well as interstate sale during the year, Your Lordship. Amongst those, I made my sale to Rajasthan parties. To Rajasthan parties, I made substantial sale. They paid the consideration money for the entire supply of my goods. They issued the C form accordingly, and ultimately, Rajasthan authority, upon inquiry of the West Bengal authority, informed that C form were issued wrongly to the Rajasthan authority. They have admitted, Your Lordship. It was wrongly issued. It was issued by the Rajasthan authority, but wrongly. And after that, the West Bengal authority was of the view some of the transporters were not found in existence. And only on these two bases, the assessment was made. And insofar as the assessment under the VAT Act is concerned, the entire sale I made interstate was taxed under the VAT Act, Your Lordship. And insofar as the Central Act assessment is concerned, some amount was refundable to me. And insofar as VAT Act is concerned, they impose an additional tax of 6 crore. So under these circumstances, I preferred an appeal. Appeal was confirmed, Your Lordship, on the same line of assessment. Thereafter, I preferred the revision before the revisional board. The revisional board was not convinced insofar as the C form and the existence of the transporter as contended by the department. So they were not satisfied. They rejected the contention and they said after elapse of so many times, after elapse of months or 2 years, you have examined the transporter and the entire inquiry report is bad. And insofar as the C form is concerned, it is not also tenable. Thus, suddenly the authority, that is the revisional authority, considered the ground of payment. They considered payment to be the clinching proof to establish the situs of sale or the nature of sale. There is no provision under the law to decide one particular sale to be intrastate or interstate on the basis of payment only. Kindly come to
that is one of the factors. That is one of the factors.
To determine the sale, it is not the factor, Your Lordship. For the purpose of sale, there should be consideration. That is a factor. That is a factor. And consideration has been defined, Your Lordship.
And you have lost before all the authorities as well as before the tribunal.
My Lord?
You have lost before the first appellate authority, revisional board and the tribunal.
The revisional board only considered the amount of payment, Your Lordship. The amount of payment, I kindly come to page 69 once. I have given.
We have to hear the appeal.
No.
Hear the writ petition.
Yes. The writ petition is not on that, Your Lordship. The thing, I kindly come to the revisional order, page 62. It starts from the page 62, Your Lordship. The revisional order before the board. And in courts of, kindly come to the page 67.
Then we will give them a chance to file a return. What is it?
No, Your Lordship, kindly hear me once. So against this, so as the revisional board considered the payment to be clinching proof for deciding whether it is an interstate sale or intrastate sale. And as the entire amount of intrastate sale has been taxed under the VAT Act, so I had the occasion to file 2 applications. One before this Honorable Court, Your Lordship, Honorable High Court, and another insofar as the VAT Act is concerned, before the West Bengal Taxation Tribunal. Because under the Act, under the VAT Act, they have taxed. Insofar as the Central Act is concerned, it was refundable to me, because that has been disallowed, Your Lordship. So now the impugned order is at page.
What happened to that writ petition?
That writ petition was dismissed for default. In this High Court, it was dismissed for default, Your Lordship.
You didn't file a restoration application.
It was filed and it was again dismissed for default in the year 2019, Your Lordship. But at that point of time, this particular application before the tribunal was pending, where the same question was there. And the tribunal...
We will give them 2 weeks' time. Let them file their affidavit in opposition.
My Lord, my Lord.
That matter has to be heard.
My Lord.
Because the tribunal also reserved judgment and then delivered judgment.
Delivered judgment only on the ground as because the application before the Honorable High Court has been dismissed for default. Therefore, we are not entering into the merit and the entire disallowance of central sale.
All right. Let them respond to your grounds.
My Lord, my Lord.
The respondents are directed to file their affidavit in opposition within 2 weeks from date. Reply, if any, within a week thereafter. List the matter after 4 weeks.
I'm grateful.
Real number 2.
Right, please, Your Lordship. My lord, this is income tax matter, my lord, for the assessment year 18-19, my lord. Here, my lord, I am, with greatest respect, my lord, landed single judge dismissed the writ petition and also stated that there is appeal liberty available before the appropriate authority in accordance with law, my lord. But no limitation ground not mentioned, my lord. What happened, my lord? I am challenging here, my lord, 147 order read with section 144 and 144B for the assessment year 18-19 and show cause notice, and also, my lord, first part, that is 148 capital A small b d and 148 notice. I am coming on that part later, my lord. And my lord, landed single judge.
No. 148 AD order you did not challenge.
In the writ petition challenge, my lord.
No.
After
You allowed the reassessment to be completed, and against the reassessment appeal.
Yes, no. Against that assessment, my lord, I challenge. What, my lord, small issue involved. In the show cause notice, my lord, only 4 days time given. Landed single judge dismiss, relying your lordship judgment PL Goenka, saying that SOP is not mandatory. My lord, with greatest respect, my lord, that PL Goenka judgment based on 2018 SOP that was not under the ambit of 144 capital B, because 147 it was amended and added with 144B from Finance Act 2022 and categorically stated in subsection 6 and subclause 11 that standard procedures shall be followed. Because, my lord, in the show cause notice there is no time limit in the statute, but in the subclause 11 says that in this procedure that it is shall, and accordingly your lordship held in the case of Indu Goenka and Green Valley, your lordship rightly held that SOP is mandatory and 7 days time. But, my lord, at the point of hearing, I was carrying only the 2 single bench judgment passed by Honorable Justice Raja Basu Chaudhary. It was before Honorable Justice Parthasarathi Chatterjee, my lord. And, my lord, at that time, my lord, that's 2 judgment I was not carrying, my lord. So, my lord, according to me, my lord, that that matter may be remanded to the 147 show cause notice state so that I can submit reply accordingly, my lord. Only 4 days given because SOP says, my lord, 7 days. I will show your lordship.
But at what stage can you raise this objection? Reassessment is over.
Yes, my lord. But, my lord, only 4 days time given, my lord.
That can be.
And the 148 AB notice was issued sometime in 2022.
Yes, my lord.
And kindly have a look at the list of dates, my lord, have prepared. It will be, my lord,
and I have also prepared, my lord.
helpful to your lordship. To relevant dates, my lord, if your lordship kindly turn.
File an appeal. File an appeal.
And, my lord.
Sir,
Yes,
if you have not challenged the 148 AD order,
yes, my lord,
which was on 26th of March 2022,
index factor then.
by raising
Yes,
this
my
point,
lord. I agree, my lord. I agree.
by raising this point, it is deemed that you are not aggrieved.
Yes, my lord. I agree, my lord. My lord. Importantly, another important fact, my lord, before your lordship, my lord, that here there is no tax evasion because, my lord, my activity is I am the customer service agent of the nationalized bank, that is Bank Mitro in the village area. So my only commission income is 2,13,000 as per their allegation. And also I have the cash deposit because my nature of activity is cash deposit because I acted on behalf of the bank, deposited from the customer in my account, and my account I deposited to bank. Deposited to bank. So there is, as per allegation, only income is 2,13,000. This is the important factual aspect. But in other cases, my lord, that bogus credit issue, nothing is, my lord.
So, my lord, if
I am
lordship,
leaving to your lordship, my lord.
148 AB notice was issued indicating all these materials to him. He chose not to reply. 148 AD order has been passed. If your lordship kindly take, my lord, the list of dates which, my lord, I have handed over. 148 AD order. Thereafter, my lord, as many as 7 to 8 notices, my lord, that has been served upon him.
Yes, correct. I am not.
You raise all the grounds in the appeal.
Yes, my lord. Yes.
The first appeal.
My lord, and my lord, appellate authority shall not reject the appeal on the ground of limitation, my lord. And all the point of the writ petition may be raised. I'm grateful.
This intra-court appeal by the writ petitioner is directed against the order dated 30/6/2025, by which the writ petition filed by the appellant challenging the order, the notice issued under section 148A, capital A within bracket B, comma, the order passed under section 148, capital A within bracket small d, comma, and the subsequent proceedings initiated by issuance of notice under section 148, etc., ultimately culminating in an assessment order dated 21/3/2023, passed under section 147, read with 144 capital B of the Income Tax Act 1961. The learned single bench was right in not entertaining the writ petition and giving liberty to challenge the impugned orders before the appropriate forum in accordance with law. The learned single bench had taken note of a decision in the case of PL Goenka. Where is the citation?
PL Goenka, my lord, at page number 23, my lord, middle portion. By my despiteful, that judgment is not applicable, my lord. Page 23, my lord.
What did I say, sir? PL Goenka. No, Principal Commissioner of Income Tax 9, Kolkata versus PL Goenka, ITAT number 241 of 2024, and dismiss the writ petition. It is a submission of the learned advocate appearing for the appellant that the decision in PL Goenka will not be applicable to the facts of the present case, as that pertain to a standard operating procedure within bracket SOP adopted by the department under a different notification.
On the context that the reopening satisfaction on the bogus credit issue, that was 10 January 2018 SOP. At that time, the 144B was not unbid under.
What is the date of that SOP?
SOP 10 January 2018.
Please read that sentence.
And my SOP, my lord.
But my lord, in PL Goenka, your lordship, my lord, had made a general observations regarding the fate of every circulars.
Not be applicable to the facts of the present case, as that pertains to a standard operating procedure.
Dated 10th January 2018, whereas what was relied on,
yes, my lord,
and what is relied on by the appellant is the SOP dated
SOP 3rd August 2022.
3rd August 2022.
And
in our view, this issue need not be gone into, and the appellant should not be non-suited on this ground, since we are of the view that the appellant should file a statutory appeal as against the assessment order dated 21/3/2023. In the light of the above reasoning, the appeal is dismissed, affirming the ultimate observation made by the learned single bench. Full stop. The appellant is directed to file the statutory appeal before the appellate authority within a period of 30 days from the date of receipt of the server copy of this order, and upon complying with the pre-deposit condition, the appellate authority shall take up the appeal and decide the same on merits and in accordance with law, without rejecting the appeal on the ground of limitation. It is made clear that any observations made by the learned single bench in the impugned order or observations made in this judgment and order will in no manner prejudice the rights of the appellant to canvass all grounds before the statutory appellate authority.
My lord, subject to correction, my lord, that pre-deposit here, my lord, is not mentioned in the statute. In the GST, it is mentioned in the statute.
All right, strike out that.
Pre-deposit, my lord, point.
I'm getting.
My lord, may I pray one thing, my lord, that a similar matter I will appear on Monday before the division bench of circuit bench. May I pray, my lord, this order may be available in the server on Friday, my lord. I'm grateful.
Done.
Similar case, my lord.
Number 3. I'm grateful, my lord.
इसको मारा ट्विस्टेड रखिए
Tuesday, मतलब कल
Tuesday मतलब next week Tuesday.
next Tuesday, ठीक है.
Not only one thing, my lord, before your lordship kindly keeps it on next Tuesday, my lord, subject to your lordship's convenience.
He is objecting.
No, I'm not objecting.
But this order is correct, Mr. Shah. Declaration prayer. Consequentially, you are challenging the order in origin. You succeed in the declaration, O and all go. In the interregnum, how to stay that order?
No, my lord. The point, my lord.
Or we can do one thing.
No, my lord.
This serial number 3A of whatever notification, they can, file a affidavit in opposition. So far as order in original is concerned, you file a statutory appeal and we'll ask them to keep the appeal in the call book.
My lord, I will point out, my lord, what is the issue. My lord, I will not go to the extent of, my lord, there are two things, my lord. One is that, my lord, the entire issue can be adjudicated, my lord, decided by the writ court, my lord, on the ground of limitation. But section 70.
Then you do one thing, you give up the prayer for declaration.
I will give up, my lord.
We'll record so. He will file his affidavit in opposition in the writ petition within 2 weeks. We will request the bench to take up the writ petition.
But kindly hear me on Tuesday, then probably your lordship will be in a position to decide the issue. 5 minutes, my lord, your lordship will be able to.
The short circuit won't work out, sir.
But very short issue.
Let us see. At the request of learned advocate appearing for the respondent department. When do you want it? Tuesday, yeah? All right. Tuesday, under the same caption.
We are appearing with the state respondent.
You are for?
State respondent.
State respondent. You are senior government pleader.
Additional government pleader.
I appear for union of it.
In this matter, my lord, Mr. Somrat Singh, senior advocate, is appearing the behalf of the appellant, my lord. He will be moving the matter, lordship.
4 days.
Yes, sir. So I am here for
A1.
only notary, lordship.
2 occasions, your
Yes,
friend,
sir,
she
lordship.
said
I apologize,
he is
lordship.
suffering from high fever, etc. Because I was also suffering, I said, all right. Now today, what is the reason for adjournment?
Lordship, he will be moving the matter, lordship.
Why can't you move the matter? Someday you have to move some matters.
Consecutive 4 days paid for it. Every day I am appearing.
Every day is senior is coming, no? You should have informed senior earlier. Morning itself, you
And
could have.
since the appeal is pending, my lord, the contempt petition which is pending before the honorable court, my lord, they are not taking cognizance of that. Since the appeal is pending, till today, no affidavit in reply has been filed to the affidavit in opposition. I have filed within the time as stipulated. And kindly, my lord, have a look to the order that was passed, referring the report submitted by the state. Order was passed. Their report.
This is the 4th occasion where there is on which adjournment is sought for, on the ground that the advocate who is to appear for the appellant is not available.
Lordship, led by Miss Ponna also, lordship. She will be coming, lordship. Praying for short pass over, lordship.
Pass over not possible today. Then you say, we'll have it tomorrow.
Tomorrow.
All right, list tomorrow.
Tomorrow, lordship.
Last chance.
Mm.
Tomorrow, my lord, has a last chance.
Last chance.
Number 5. My lord, that matter can it be kept on Friday, my lord? Next Friday.
Right.
Item 3. Right. Item. Great.
The matters relating to, my lord, whether the single writ petition can lie.
You pay additional court fee.
Yes, paid additional court fees. No problem.
But
My lord,
in the appellate side rules,
yes.
Does it have any particular provision? How more than one person can join?
My lord, I have the authority, my lord, I shall be placing. Before that, my lord, your lordships kindly. These are the petitioners. All are, my lord, who are seeking for the compassionate appointment under dining hardness category. Now, my lord, they all have been done in a list
some of them have been given appointment, we have been deprived. On a single list, that list I have annexed. That was the subject matter of the challenge before the trial judge. But the trial judge said, no, you have to.
It is restricted to only one petition.
Not the one. That's why I filed the writ petitions that challenging on that portion, not a merit. Merit that will be decided by the trial court. Whether the single writ petitions can be.
You have paid.
I have paid the court fees.
For 7 petitions.
Yes. Now, your lordships kindly, I shall be placing the certain judgment, your lordships kindly before the single bench to the.
As per the rule, if he has paid individual court fee for all the petitions, it must be permitted.
It is yourself.
What is this, sir?
দিয়েছি আমি জল থেকে হ্যাঁ আচ্ছা কপি না আমার কাছে দেখে না ঠিক আছে
Order 1, rule 1.
Now, the discussion was made. The applicability of 226.
All right. This intra-court.
Now we're at the division bench. It is Joseph. এটি ফুল বেঞ্চের তো ফুল বেঞ্চের সবকটা এই দিয়ে আছে এই করা আছে না কেটে তো এটা সিঙ্গেল বেঞ্চ প্যারা 11 মানুষ সবটাই কোথায় আছে
But this was also a home guard matter.
Yes, they also home guard matter. But now the full bench this will be the full bench judgment of the Allahabad High Court.
84 full bench will not certainly different on certain points, my lord.
Page para.
If the cause of action is identical.
25, 26.
Yes, but the cause of action is here to some extent different.
Page 25, I'm coming. 25, 26, para 38 and 40. Single bench data দাও আর 8 কোনটা আছে প্যারাগ্রাফটা দেখো তো 11 and 12 12 15 এটা এই করা নাই তো দাগ দেয়া নাই তো
But in the division bench judgment relating to this home guard, what did the division bench say? You pay individual court fee?
Yes, sir. Even court fee I have done. There is no dispute.
There's no. This intra-court appeal by the writ petitioner is directed against that portion of the order dated 21/11/2024, by which the learned writ court restricted the writ petition only in respect of petitioner number 1, and petitioners numbers 2 to 7 were expunged from the array of petitioners, and that they will be entitled to file a separate writ petition on the same cause, if otherwise not precluded from doing so. Admittedly, the cause of action for filing the writ petition in respect of all the 7 petitioners are identical. and all the 7 petitioners have paid individual court fee. In such circumstances, the petitioners should be permitted to join together and file a single writ petition subject to payment of individual court fee, which has already been done by the petitioners. We find support to this conclusion from the decision of the Honorable Division Bench of this court in the case of Parul Devnath and others versus Union of India, 2006 SCC Online Calcutta CAL 25, and the decision of the full bench of the High Court of Allahabad in the case of Umesh Chandra Vinod Kumar and others versus Krishi Utpan Mandi Samiti, 1983 SCC Online Allahabad 638, and the order passed by the learned single bench of this court in the case of Juleka Nazreen and others versus State of West Bengal and others, WP 26842 within bracket W of 2016. Accordingly, the appeal is allowed and the order passed by the learned single bench is set aside, and all the 7 petitioners are permitted to join together and expose their cause in a single writ petition, as already all 7 of them have paid individual court fee. Accordingly, the cause title of the writ petition be restored to its original position, and the respondents are at liberty to file their affidavit in opposition, raising all contentions. Allowed.
Extremely good.
Great.
Next.
Petition number 6.
My lord, in this matter, I am led by Mr. Bimal Kumar Sai for the state respondent.
My lord, I am for the petitioner in this matter, my lord. My lord, it's an unfortunate case. The petitioner was engaged as accredited social health activist, that is Asha Karmi, which is in contractual engagement up to 65 years, my lord. My lord, she was given the engagement letter. She joined the post, but there was a provision for orientation course for 7 days. My lord, her mother met with a road accident. She prayed for time that I cannot join. My mother has died. Eventually, she succumbed to death out of that accident. So she could not participate in the orientation program, though she was appointed already. She got the engagement letter, she joined, but she could not attend the orientation program. Now, after that, yes, admittedly, my lord, in 2025, I moved this writ application saying that kindly allow me to join since you have not terminated my service and the post is still vacant. Though it has been submitted
but before the court they said one Mamta Sinha.
It is not our instruction. There is no such person who has been engaged.
Whether they produced any written instruction?
It was a submission. Nothing was produced. It was a submission based on which it has been done.
Is there any
allowed to make a submission?
Yes, Mr. Sai.
My lord, petitioner was initially joined as a Asa Karmi. Thereafter, one complaint we received from Mamta Singho. And after going through the investigation, it was found, while report his memo number BMH OH so and so reveals that her address, there was typical error by the local BDO, and Thakur Bari was Puratan Thakur Bari was mentioned there, but it will be only Puratan. Address will be only, vacancy was only for Puratan, my lord.
So far, I can understand what my learned friend is saying. There was some typographical.
First.
You please hand over the written instruction given by the department.
Okay, my lord, I am handing over. My junior will hand over to my learned friend.
And I don't have my lord.
My lord, Babta Singh is the
Your
higher
junior,
score.
sir, your junior is saying he does not have it. Where is the written instruction given by the department?
I have no written instruction. Allow me to file the opposition in form of affidavit, my lord.
Not required, sir. You get a reply from whichever who is the appropriate respondent on the factual.
SDO, my lord.
Who?
SDO, subdivisional officer.
Who issued you the engagement letter?
It was issued by my lord, Secretary BHFW, that is Block Health and Family Welfare Samiti.
Page.
That is page 46, starting from 45. And the authority,
But have you implemented him?
BMOH is the secretary.
Sir, who is the respondent
Yes,
who have to
I'm telling your lordship.
who
I'm
have to
telling
give instruction?
respondent number 6, the block medical officer. Right? 6.
We have heard so
number
also.
party kota
The learned
party
sixth respondent he is directed to give written instructions to the learned government council on the grounds raised by the appellant in this appeal. This is the matter after 1 week
member secretary.
under the same caption. Next.
It has been made returnable, my lord.
1 week after.
I'm so grateful to your lordship. Extremely grateful to your lordship.
Yes.
Your Lordship, in item 7, I am appearing for the appellant. Lordship, in item number 7, I am for the respondent number 1, Lordship. Your Lordship, we have noticed that it's a group 3 matter, but somehow maybe in the form A there is a that it is appearing in group 4, Your Lordship. So, Your Lordship is not having the jurisdiction of group 3 matters, Your Lordship. So, I think I need to correct the form A. Inadvertently, maybe the mistake is there.
You have to correct the memo of appeal.
Your Lordship, leave may be granted to correct the form.
Yes, already leave is granted by the registrar L&OM.
Your Lordship, that defect was not pointed out. The defects were that the added respondents were not made a party. So we had made those corrections, Your Lordship. The defects were cleared. But later on we noticed, today in the morning we noticed that inadvertently it is coming under group 4, but it's a group 3 matter, group 3 appeal, Your Lordship.
Otherwise, Delta Limited, we would have dismissed your appeal.
Your Lordship, 1 day more to live to go to another court.
I think separate division bench has to be created for Delta Limited. So many matters you are filed. So it's a group 3 matter.
Yes, Your Lordship, group 3.
The learned advocate appearing for the appellant submits that due to inadvertence in the presentation form, the appeal has been shown as a group 4 matter, whereas the correct classification is group 3. The learned advocate for the appellant is granted leave to correct the presentation form, and upon correction, the appeal be listed before the Honorable Division Bench having determination.
Grateful, Lordship. Grateful, Lordship.